Hey, welcome back, faithful politics listeners and watchers. I'm your political host, Will Wright, and your faithful host, Pastor Josh Bertram, is out on a top secret mission I can't tell you about. But today we have with us my favorite Manhattan prosecutor, Diana Florence, returning back to us to talk about all the Trump things. So, welcome back to the show, Diana.
Thank you. Great. Always great to be here.
Before we get started, I have to ask because I feel like we've talked about this in the in some of our previous discussions about where you're at on the Daredevil series and if you finished it or
I've I've stalled because my son is away, but my son is actually on his way back today, so I will pick it up. So by Trump 3, I will be I promise to be mostly through it.
I was going to suggest that also even like the She-Hulk would be a good one because she's a lawyer that in the comic book she's actually like a lawyer to a lot of the mutants and whatnot. So it's a really interesting series, but. Anyways, I won't belabor the point. So we're here to talk about the Trump trial in New York, the hush money payment trial. So maybe you can just start us off by giving us sort of a high level view or explanation of this particular trial and what it's all about.
Sure. So the trial that's known as the hush money case really has to do at the end of the day with rather run-of-the-mill charges. There is about, I think, is it 34 charges
Mhm.
of falsifying business records in the first degree. And essentially that's a state crime. It's a lowest level felony here in New York. And it's all one course of conduct, meaning all while it sounds like a lot of charges, it relates to some payments, a payment that was made to Stormy Daniels by Michael Cohen when he was Trump's lawyer. And in order to make that payment, Michael Cohen used his own funds and then was reimbursed by the Trump organization for double the amount of money that he paid because Cohen was booking it on his legal practice records as legal services. And on the other hand, so did the Trump organization. They reimbursed it. They paid those monies, $130,000 roughly. And the reason that there are 34 counts is because each count relates to one of the payments. It was a series of payments I believe in 2017 after Trump was already in office, even though the original hush money, if you will, was paid prior to the election in 2016, but it was a series of payments, and that's why each one of these charges relates to an entry in the business records. The reason that this is a felony and not a misdemeanor in New York, if it were just a false statement in the records, that would be a misdemeanor, but it rises to a level of a felony because there is the prosecution's theory is there was another intent to commit another crime. And they've posited that there are various other crimes. One, of course, being tax fraud, and then, of course, being campaign finance rules, which are a little bit obscure because this is a state prosecutor using a federal law, but there's also a very obscure state law that relates to federal elections. So all of this is to say is because these false entries were made to conceal the fact of what they actually were with an intent to commit another crime, that's why we have felonies. So that's what it is. That's what the charges are. And I believe, next week we're going to have what we call summations or closing arguments.
Got it. So when you said it's like a low level misdemeanor that is sort of wrapped around like a felony or something, just so I can kind of understand it, like what would like a second or third degree misdemeanor of this type like entail? Like what is it about that makes it a first degree versus something a lot higher?
Yeah, I don't sort of be fooled by the degrees. I mean, obviously, like a first degree burn, obviously, is that better or worse than a third degree burn? I always forget. But in criminal cases, first degree is the worst. But falsifying business records obviously is a lesser crime. So there's only 2 degrees of falsifying business records that exist. Falsifying business records in the second degree is a class A misdemeanor. That's the most serious misdemeanor. What it really means is that you can be punished by up to 1 year in jail. When you go to the felonies go from E to A, the lowest level felony is an E felony. This becomes an E felony because it's punishable for a first time offender of up to 1.25 to 4 years in prison. And again, the difference between second degree and first degree, second degree just says, if you booked this as legal services, if you just wrote the lie with no other intent, that would be a misdemeanor. But because the prosecution is saying there was intent to get around campaign finance laws, which is another crime, and also to keep the tax authorities at bay, that's another crime, tax crimes. That's what elevates it from a misdemeanor to a felony.
Got it. So since you used to work in that office, I'd
Mhm.
imagine you're probably somewhat familiar with maybe some of the prosecutors that are on the case. And I wrote the names down. It's Matthew Colangelo, I think that's how you say it. Joshua Steinglass and Susan Hoffinger.
Hoffinger,
And
yes, Hoffinger.
I'm wondering like what skill sets do they bring to the table that are beneficial to the prosecution team?
Yeah, so Matthew Colangelo, I believe, was either I think he was in the Attorney General's office. So he came relatively recently. I didn't know him, but I did know Susan Hoffinger was a defense counsel for many years. She was in the DA's office many years ago. I knew her as a defense counsel. So she actually very much brings the white collar experience defending white collar defendants, and I did many a case with her. And Joshua Steinglass is also, he's a longtime prosecutor. He's done many trials. So they're both, very experienced.
Got it. And do you know anything about Todd Blanche or any of the defense team?
I mean, again, Todd Blanche, I believe, was a former federal prosecutor. Susan Neckles, or Necklace, I believe. I knew her. She's also a defense counsel. In fact, I had many a case where Susan Hoffinger and Susan Necklace were co-counsel. Many of these large, cases that I did in the construction industry had multiple defendants. So she's very experienced as well.
Got it. So talking about the case or the trial, like what do you think? What do you believe are like the strengths and the weaknesses of the prosecution's case against Trump?
I mean, it's a fairly straightforward case. A lot of the strengths are the kind of mundaneness of it. At the end of the day, we're not talking about a he said, she said. There's paperwork, there's representations. And then of course, there's social media of Trump himself saying things in real time, not things now during the trial, but back when when I think Cohen was still on Team Trump, that could be seen as, excuse me, admissions. And so I think that in general the case is, it really is not so much dependent on Michael Cohen, who's probably the biggest weakness because he's obviously, he was on Team Trump.
Yeah.
He was now he's a cooperator, but he's very much he's not a he's not a person that is a trustworthy kind of pillar at
Sure.
this point, because he was so vehement one way, and then of course at some point he joined the other team and he became vehement the other way. So I'd say he's the biggest weakness because everything he says has to be corroborated. Fortunately for the prosecution, I think there is a lot of corroboration.
Yeah. And based on my reading of the trial, it seemed like he handled himself decently on the stand. I mean, I think there was sort of this concern that his like podcast persona would would like
Yeah.
come out while he was on a stand, and it didn't appear that way. But like it's
Just because somebody is icky doesn't mean they're not telling the truth, right? That's
yeah. Well, like to even bring somebody like Cohen onto the stand, like what type of deliberation would be going on, because everybody, at least out in the public, are thinking, really, they're going to bring that guy on, and so I'm sure that there was probably, I don't know, a lot of sort of stress, anxiety about how's he going to handle himself. So can you maybe just talk about how do you, one, like, how do you decide this is the guy that you think you want to bring on despite his integrity issues? And then two, like, how do you prep, or do you prep at all, like the witness?
Oh, well, for sure you prep him, but you also understand that when you make a decision to use a cooperating witness, so a person, again, who, at some point was part of the in crowd of the crime. And then at some point they made a decision to turn and to sort of give, to confess, if you will. And obviously they don't do that of the goodness of their heart, they get a benefit, right? They're not going to be facing the full kind of, I guess, thrust of what they could face. Um, but understanding that you yourself, when you were investigating, 5 minutes ago, thought he was, not the greatest person, right? And not, and certainly someone that needed to be prosecuted. It would be kind of hypocritical to just say, well, now he's my guy, right? And I think smart prosecutors are not going to be like that. So many, many times I did a lot of corporate prosecutions, and invariably there would be an insider who would flip, we call it. But what would happen is you would look for as much what I call corroboration as possible. So that means emails, text messages, other witnesses who've heard things, bank records, anything that will be objective or happened, sort of in, contemporaneously, or in real, at the time that these crimes or the plot was sort of being hatched, if you will. So all of that is to say that the way prosecutors, a smart prosecutor, will handle this is they will stand up and they will say what's obvious, which is, yeah, this guy's ridiculous, right? I mean, he was on Team Trump for forever, and then just only in the last however many years, now he's, team prosecution. Of course, that's ridiculous. But just because he's ridiculous doesn't, again, just because he's icky, just because he's ridiculous doesn't mean he's not telling the truth. And so in this case, here's why we you can credit his testimony despite acknowledging all of his weaknesses, all of his ridiculousness, all of his statements that all of what I think he admitted to stealing some money, right? Wasn't
Yeah,
there?
yeah, yeah.
I mean, he's so ridiculous. But again, just because he's ridiculous doesn't mean that it isn't actually true what happened here. And the jurors are going to be charged by the judge after the summations. The judge is going to charge the jury, and part of what he's going to charge them about is credibility of witnesses, thinking about the fact that he's getting a benefit, all of those things. And as a prosecutor, you obviously know that, and you're going to argue and say, look, these are all things you should consider, but also consider what he said in light of exhibit whatever, exhibit is this, exhibit that, all these different things that are objective or and corroborate him.
Interesting. So I guess that actually ties into another question I had about like jury instruction. So yeah, they're going to be doing their closing arguments, but then I've read, there will be jury instructions given by the judge. So like as a non-legal person, like what the heck are jury instructions, and like how important does it play into the verdict of this case?
Oh, well, it's very, very important. So the way it works is the in New York, and I think in probably every state, right? I mean, whoever in the law in general in the U.S., whoever has the burden goes last. So if you were the plaintiff, right, in a civil case, you would go last. If you're, and if you're the prosecutor, you go last. And what I mean by go last is for summations or closing arguments, the Trump team will go first, and then the prosecutor will go last. And then after that, the judge will charge the jury. Now, what they say in their closing arguments is not evidence, and it's going to be their kind of, encapsulation of what happened in the trial. And if I'm the defense, I'm going to be pointing out holes. This is why they did not meet their burden. But again, because the prosecution has the burden, they're obviously taking notes, right? I mean, not that there's going to be anything too surprising, but if they're going to be able to respond to those arguments. So after they each sit down, the judge will charge the jury on the law. So what happens is, in this case, there's really only one crime, falsifying business records in the first degree. So he will read them what's known as the CJI pattern jury charge. So CJI stands for Criminal Jury Instructions, and it's a New York State kind of template, if you will. You can Google it if you want, and you can Google any crime in New York. You could do murder, CJI, and you could find the charge. So in this case, you can find the falsifying business records charge, and it's what the judge will say. They really use that exact charge because, frankly, it's been vetted by the courts of New York. If you follow it, there's not going to be an appellate issue because you added extra stuff. So it's going to be fairly regular. But that's not the only, even though there's only one charge, right? There's 34 of them. That's not going to be the only thing that the judge is going to charge the jury on. They're going to charge them on different things. Now, before these summations, and I think it might have happened already, or maybe it's happening today. They do something called a charge conference. And so that just means the judge says, okay, here's what I'm thinking. These are the things I'm thinking of charging the jury on. Do you have any suggestions? So the things other than the actual substantive crimes, right, falsifying business records, that the judge is going to charge them on are going to be things like credibility witnesses, cooperating witnesses, circumstantial evidence. There are different charges, and again, if you or your listeners are super bored and you want to peruse this GI, you can see all the different things. Again, there's some standard ones, and then there are ones that are that pertain to the case. Not every case has a cooperating witness. So the charge itself, I don't expect it to be days or anything like that. It should probably take usually in a case of this type, meaning an e-felony, it probably is a morning. There's going to be there are going to be charges about how to deliberate. It's obviously, once again, the fact that it's a high profile case, not to look at newspapers or that's already been admonished, but that'll be part of the charges as well. But yeah, that's kind of what the charge will be. That's ultimately when the judge sends the jury back into the jury room, he's going to send them with what's called a verdict sheet, which will have all 34 of those counts, and it will say guilty or not guilty, and it's literally a check mark. And then they have to go through, and obviously they vote. It has to be unanimous. It's a criminal case, and although not every state in the union requires that, New York, of course, does. So it's not going to say, 12-0, or if they acquit, or if it's a hung jury 6-6. I mean, it's going to be check if it's guilty. And that's how it will be. And so in order, there'll be, there's a 4-person who's already been chosen because it's by whoever is the first juror. Juror number 1 is the 4-person, and they're the one. And all that means is they read the verdict, and they sort of help kind of lead the deliberations. They don't get any special power or anything like that.
It's so wild. Like, I've never served jury duty, so I'm always interested of peek behind the curtain to see how it goes. But like you said, it has to be unanimous. So everybody has to. So before they can leave the room or whatever the thing is over, they all have to agree whether guilty, 34 counts, guilty or not guilty.
Well, they all have to agree unanimous for each count. So theoretically, they could say, count 1, we think he's guilty. Count 2, he's not guilty. Count 3. Now, I don't want to get too in the weeds here, but that in this particular case, that would be what known as a repugnant verdict. And the reason why is because if you credit what happened here, right? Because at the end of the day, it's a narrative, right? That's why Stormy Daniels even testified, right? Because she had nothing to do. She has no idea how they booked it. She got her money. But what it is, though, is that if you believe that they did in fact say these were legal fees and that they were not, and that the intent was to circumvent, either federal election laws, state election laws, tax laws, then you find it guilty. You wouldn't find it for, for the check from November, but not the check from February. That wouldn't make any sense. So if they were to do that, that would be an appellate issue, or even something a judge could do in court. Or he might send them back actually to say like, this isn't, before he accepts and say like, this isn't, if he sees the verdict sheet, that would, it's a little bit uncomfortable. I mean, there are repugnant verdicts, but I don't think that will happen. So the unanimous thing, to be clear, is per charge. You can acquit on certain ones and certain not.
It's so like I would hate to be that foreperson. Like, I mean, just to like herd all the cats. And like, what if you're, I don't know, what if the foreperson is just like a major introvert, that has high anxiety or something? Like I feel like all of them.
Theoretically, in the jury room, they could, if they are high, say like, I'm not super comfortable with this. Hey, Will, you take over, and you could lead it. I mean, truth is, we don't know, the parties, the public, the lawyers, even the judge. We don't know who's actually leading it in there. Generally, that's who it is. But if it were like, hey, Will, you're more of an extrovert than I am, that's fine. But ultimately, when it's the verdict sheet is signed by the foreperson, and ultimately, when the judge takes the verdict, and he said, hey, members of the jury, how do you find the defendant on count one, guilty or not guilty? It's going to be the foreperson who will say, who will read the verdict. Now, afterwards, there's something called polling the jury. So the defense attorneys often do ask, they have each one of the jurors say, is that your verdict? Yes. Yes. So just to be sure, because what if it does occasionally happen? We're like, no, that wasn't my verdict. And then you have to go back in because again, it has to be unanimous.
Got it. So, going back to witnesses, I would probably say the most salacious witness they had was Stormy Daniels.
Yep.
And felt like there was a lot of like viral moments that came out of her testimony. So, how important was her testimony, you think, to the overall narrative of what happened?
Well, you had to have her because it is important to understand the stakes, right? As much as you don't have to prove motive, if it just seems out of the blue, like I just went ahead and directed they falsify business records, it doesn't make any sense. So she was important for the prosecution to call her, even if the technical elements didn't require it. The level of detail that she went into perhaps was more than I would have expected. I think that the defense objected to some of that. I think there could have been more detail. I mean, we all are aware of some of the more, as you said, salacious details about, the intercourse between her and Trump. And I don't think she thankfully went into that in court, other than to say, but I think it's important and relevant that she says that they slept together. I don't think it's relevant about the quality of what happened in the room or not. That has nothing to do with the payoff.
Yeah, yeah. I mean, like how much of because I know the defense had brought up sort of like their fundraising, or I don't know, trying to promote things related, if not necessarily to the trial, but to Trump, so like for Stormy, she, I don't know, was doing something with like the 45 like it implied in whatever it is she was
Oh
selling,
yeah.
and like in Cohen as well. Like how much of that kind of stuff just hurts like the prosecution's case?
I mean, I think that anyone going into this understands that this is an adult film star and a disgraced former attorney, who worked for as Trump's right hand for many years. They are who they are. I mean, the prosecution would look foolish, and I don't expect them to, in their summation, argue that these are trustworthy, and the pinnacle of integrity and ethics. I mean, yeah, I mean, it's a little bit tawdry, right? I mean, selling 45 scotch or whatever it was. I mean, it's right? I mean, but it is what it is, right? I mean, that doesn't, again, I find Stormy Daniels to be more sympathetic, actually. I don't find Cohen to be at all. Um, and I actually thought it was very interesting, the defense's cross examination of her, because I thought that it was a bit of a mistake to go after her because at the end of the day, she was paid. I mean, I think you could have done it a lot shorter. You could just basically say very matter of factly, you were an adult film star, you wanted to be on The Apprentice, you saw, you had an evening with Trump, and you're an opportunist, and not be so, I don't know, mean. It was, to me, it was like, it was a little mean. And if it's, to me, a little mean, I think jurors might see it that way too. At the end of the day, she got her money. She got, there's nothing for her to tell the truth about. Doesn't matter. It doesn't matter if they slept together. Honestly,
Mm.
it doesn't matter at all. He obviously, whether, and I have no idea if they did or not. Trump obviously perceived that it was going to be a story in the National Enquirer, that her alleging it. So it doesn't really matter whether they did or they didn't, and that's why the hush money was paid, right?
Yeah, yeah. I mean, I suppose at the end of the day, she was able to tell her story and got paid,
Yeah,
and and is making money off of it.
yeah.
So, I mean, you go,
That's
girl, I guess.
America, right? That's America, people, right? I mean, we've lived long enough. I mean, I think you and I think I'm a little older than you, but I mean, I grew up in the '80s when Joey Buttafuoco and what was the one that Lorena Bobbitt and
Yeah,
all
yeah,
these
yeah,
people, they tell their stories, right? I mean, there's these little salacious sort
yeah.
of, Amy Fisher and this one, they all tell their stories. They do rather tawdry things. That's the word, and that was sort of, and now sort of innocent. I mean, those at least they were not presidents.
Yeah, yeah. So at one point in the trial, they had requested a mistrial
Mhm.
from Trump's lawyers.
Right.
I guess arguing the testimony was prejudicial or something. But like how common are like requests like that? And in your experience, like under what conditions are they generally granted?
Oh, they're very, very rarely granted. What that's really about is preserving the issue for appeal.
Mm,
So, do I think that it was prejudicial? No, I think Stormy Daniels is Stormy Daniels. And I think that at the end of the day, did the testimony go a little more, as I said, a little more tawdry in depth details that probably weren't relevant? Sure. Was it harmless? Yes. In the end of the day, she has no bearing on whether he committed these crimes or not. It's just giving the context. And I'm not sure, I don't really see any court saying, because she talked a little bit about their evening together, that in and of itself is going to prejudice. This is not a I mean, I don't think any jury in the US, but this is New York City. Like, we're used to we take the subway every day with people that do much worse. So,
yeah. Yeah. Okay, so 34 counts. If the jury comes back guilty on all 34, like what are the potential, ramifications for Trump? I mean, I'm assuming they're obviously going to appeal, right?
yes.
But like what are the sort of like real like consequences for Trump?
Well, there's no minimum jail sentence. In fact, he can get no incarceration at all. And
Mm,
so what that means is that bail will continue pending appeal, and the case will be appealed. That will take long after the election for the appeal to be perfected. And in New York, we have two levels of appeal. So there's the intermediate level, which is called the appellate division, and they will, every defendant is entitled, if they're convicted, they're entitled to appeal their conviction. That appeal will be perfected, even if it's done super quick. And let's say we have a verdict, I would think in June, early June. Sentencing wouldn't even be for a couple months. So I think it would maybe be August, July, August. Um, and then the appeal won't even be filed, I don't think, till after the new year. So I mean, if he's elected, it would be around inauguration would be the earliest time I could see. And then it goes to them. They file briefs. There's arguments. If they lose the appeal at the appellate division, there's one last shot. They can go to the Court of Appeals. Not every case is accepted at the Court of Appeals. The Court of Appeals is more like the Supreme Court of the United States in New York, though, just for New York cases. And there would have to be a specific, issue that they would take up, whereas the appellate division has to take every appeal. So in terms of what he could face in the short term, not too much, I would say. Let's assume, for argument's sake, that it goes through all the appeals, and the case survives appeal. Ultimately, he could face 1.25 to 4 consecutively, although I don't really think he would. It wouldn't be 1.25 to 4 times 34, because there's something called merger. And I think the max would be 10 to 20, but he's not getting 10 to 20. Again, this is reading tea leaves. I don't know what the judge, I don't know if he'll get one second of incarceration, but if he were, I don't expect that would be more than the max on a single count, which is 1.25 to 4.
So there wouldn't be any like financial penalty or anything?
The financial penalties would be very small, if there are, because it's just, but I think it's a few $1,000s per count. So it's not going to be, so $100,000 maybe. I want to say it's 3 or 5,000. I don't remember offhand. Fines are not usually given in criminal cases like this, because the numbers are so low, and ultimately there's usually bigger financial repercussions. For example, in a big construction fraud case I did, where they were falsifying the concrete at the World Trade Center, we didn't do fines because ultimately they had to remediate. They had to go back and pay for all the retesting and things like that. So that's a better way to kind of sentence it. New York doesn't have the best kind of sentencing laws related to fines. California, for example, has all these sort of provisions where there's like treble damages and things like that, even for criminal, but we don't really have that.
Oh, interesting. So really, a win or a loss for Trump in this case would really be more political than anything, right? If there's no risk of jail time, no big substantial fine, he kind of gets a black eye, goes home, and can like campaign on, how corrupt the legal system is.
He definitely has a risk of jail time. I just don't think it's going to happen. If he were to face it, he's not, even if the judge sentenced him to 1.25 to 4, the appellate division will immediately allow him to stay out bail pending appeal. So that's why he could get 1.25 to 4. I think the judge might, I think given the whole kind of gestalt of what's happened, I could see the judge giving him an incarceratory sentence. But I think the bigger thing that's significant about this case is that he cannot get a pardon for it. He can't pardon himself because this is a state crime. That's the major difference between the Fani Willis case and, the Manhattan DA's case and the Jack Smith case, because the DOJ cases, those cases can ultimately go away. If Trump were to be elected, obviously he's going to instruct the Justice Department to not continue those cases. Can't do that with the state cases.
Yeah, I guess, that makes sense. Now, how important was it that Trump did not testify, or would it have been, if they could have tamed the dragon, like if it would it help the defense for him to have taken the stand?
No. That would be a huge mistake. Huge. Bigly. Yeah.
Bigly.
No, you can't. Because this is not a rally. This is not social media. This isn't even a presidential debate where there's back and forth. There's a judge, and there are rules of evidence, and you can't just say things. And the fact is, there is a mountain of things that you could confront him with. It would have been the biggest mistake. I think in my years of trying cases as a prosecutor, which is about 25 years. I think every time a defendant testified, I won at trial. I mean, it wasn't every time, of course. And I did about 60 or so trials, 60. I never remember 50, 60, 75, something like that. But I can tell you every time a defendant, testified, because generally if it's going to trial, it's going to be a fairly strong case. And, there's a lot to confront them with. I think often white collar defendants, not just the former president of the United States, right? They think that they're smarter, right? Because, they're pillars of the community. They coach their kids, soccer game or whatever, and they think that they can outsmart the prosecutor. But the fact is, if we've brought the case, we've thought of all those things, right? We've thought of the stories they can tell. So it would have been a huge mistake. And I think his best bet was to exercise his Fifth Amendment right against self-incrimination.
I would hate to have you as a prosecutor if I were in court, because like you're such a nice person, and it's like it would be sneaky. Like you would just be like this like hardcore prosecutor that would just come out of nowhere and be like, "What happened to the Diana I know?" But anyways, that's neither here nor there.
It's funny because it was hard. Sometimes it was very hard. I once did a case with the bookkeeper at a very fancy restaurant here in New York, Gramercy Tavern, and she decided to become pregnant during the trial. She'd embezzled hundreds of thousands of dollars, and she didn't testify. But I will tell you, it broke my heart because she was going to give birth to this kid in jail, and I was like, please, I was begging her attorney, please plead guilty. I'm like, I have the evidence, dead to rights. But yeah, I mean, it's tough. It's not an easy thing, but obviously it's about justice and making sure that everyone faces the same justice. And that's at the end of the day why, as kind of mundane as this case is, look, if you or I did something similar, we would face these charges, I think. I mean, obviously these are very significant, and I don't know how, I don't know the circumstances where either one of us would ever be paying hush money to a porn star, but whatever. And then having
Yeah.
our giant company, But my point is, if we falsified our business records, we would be held accountable. And it's important that whoever you are, that we're all equal under law, even though I realize that that's not always the case. I think the more that prosecutors can do that, the more faith we can have in our systems.
Yeah. I'm going to talk about the gag orders. So Trump violated a few of them. And like, first question is like, when does the gag order lift? Because I'd imagine as soon as this trial's over, he's going to have a field day, attacking everybody under the sun. So when will the gag order be lifted?
Yeah, I mean, I would imagine that's exactly what's going to happen once the trial is over. I think that I think the major reason for the gag order is, of course, the intimidation of witnesses, and the risk that jurors would see it, even though, you tell jurors not to look. Yeah, I mean, I think that will certainly happen. It will get lifted, and he will say whatever he wants to say. I mean, the truth of the matter is, I think if you are a Trump supporter, you don't believe any of this. And if you are not a Trump supporter, you're at least listening and keeping an open mind. You may not necessarily think this is even the right thing to be doing. You might say this is a waste of taxpayer money, and that's fair. I think it depends. And certainly there's a lot of cases, which I think, does owe a little bit to that argument, even if you're not a full-on Trump supporter. But again, if you take the view that that justice is, everyone is subject to the same justice, then I think it's okay. But in any event, I think it will get lifted. I think it will, he will be talking about this if he gets convicted, and if he gets acquitted, oh my goodness. I mean, they'll talk about it even more.
Yeah. Does it get lifted like the day the verdict is provided, or is that like an action the judge has to take?
I mean, again, and it's not something, look, gag orders are very unusual. And again, though I did many high profile cases, none of my cases had gag orders in them. They're not usual. So it really will depend. I mean, theoretically, I suppose the judge could keep it in play, but I'm not sure what the purpose would be. I mean, I don't know. Did Engoron's gag order get lifted? I guess it did.
Yeah, I
I'm not sure.
don't know actually.
Right.
I
So, I
think
mean, it's possible it could continue
Mhm.
while the appeal is pending.
Mhm.
I don't know. I mean, again, there was a specific basis here, because obviously you have jurors, you have witnesses, and you don't want people to be intimidated. So that was the basis, and that's why he was, even though they kept doing what's called an Article 78, which is they went to the appellate division and said that the judge was acting arbitrary and capricious. That's a super high standard, and of course they couldn't meet it because he had a basis.
Yeah. Oh, and just for our listeners, that police siren is in the background. Diana is in New York.
Yes.
I had a friend of mine who was listening to a previous interview we did, and he's like, I kept hearing like a siren, and I was looking at my rearview mirror and all around, like it was somewhere. So if you're listening to this and not watching it, like that was on our end, not your end. You're not being followed, but you should slow down and get off your cell phone. The will the gag orders have any part to play in the appeals process? You think?
I don't think so. I mean, I'm not sure what the. I suppose they could say that he wasn't able to put on a full defense, but that I don't see how that would work. I mean, the defense happens in the courtroom, so I'm not sure. I mean, the only way I could think could see it is more in the aggregate that the judge was unfair, and that the judge kept, sort of targeting him and treating him unfairly. So that's the only way I could see it.
Interesting. What about like his entourage? So Trump brought in like an entourage on many of the days, the least of which the Speaker of the House. Although there's been reports that Mike Johnson didn't actually walk into the courthouse; he was just out front. But um, like what's the deal with that? I mean, it just seems like it's an intimidation, like sort of tactic or something. But like, is that common?
It's a public courtroom. I mean, he can bring anyone he wants in. I mean, obviously, people they can. That's part of it's part of the theater of trials, I suppose. Is it common? I mean, not really. I mean, I think certainly jurors notice. They know who's in the. I'll tell you a funny story. In one of my big racketeering cases, my daughter was she was in third grade, so she was just my son was in kindergarten. So but we thought, okay, it would be great for mommy. I'd been on this trial for 6 months, and so my husband said, I think it's good for mommy to it's for my daughter to see mommy sum up. And it was like a crazy long summation, a closing argument, I should say. It was an all day thing, but my husband said, let me bring her for a little bit, and he did. And then my daughter left. She was perfectly well behaved, whatever, but it was good kind of, parenting thing.
Mm-hmm.
And the defense attorneys object to it, even though it's not like I introduced her, but my daughter and I sort of resemble each
Yeah,
other.
yeah, yeah.
And I will say that I always made a point of not talking to jurors because I just didn't think that was my place, and I didn't, if they convicted, I didn't need to hear that it was because of my hair. I was hoping it was because of the evidence. So, I would, but one of the jurors left, and she said to me, like as she was leaving, she said, "And your daughter is so cute," and it was so funny because it's not like anyone knowledge, and to me that was just another example of, you know how these go.
So,
Let jurors see everything.
so in your time in the Manhattan office, can you think of any other cases that are similar in scope, character, that might be able to, I don't know, like the general public, like myself, could look to gain a basis on fairness. So we look at this case, we're like, okay, this verdict was issued here. The Trump case is kind of similar. So if he doesn't get, X, then that means, the system's messed up or something like that.
I mean, it's hard to say because, as I said, as a white collar prosecutor, so my 25 years, my first 5 years, I prosecuted street crimes, domestic violence, sexual assault, robberies, drug cases, those kind of things. But the latter part of my career, 20 years, I did white collar cases, right? So I prosecuted executives, companies. So falsifying business records was usually the way the case started, right?
Mhm.
Someone would notice something funny. Often There's a partner crime to it with public agencies called offering a false instrument for filing, and it's essentially the same thing. You're saying making a false statement to either the port authority that runs the airports, or the MTA that runs the subways and the trains and whatever. Because these, again, my specialty was construction. What's unusual about this case, and I think we've talked about this before, is that usually that was where the cases started, but they often led to a lot more, whether it was larceny, racketeering, schemes to defraud. So what's interesting about this is that it just stayed here. Now, there were various reasons, which I'm not privy to, but I will say that generally with document cases, they often plead guilty, right? Because number one, there's not mandatory jail. Number two, often the evidence is pretty strong. And I would say the argument, the evidence rather, is very strong here. If you strip away if you just called everyone John Doe and Jane Doe, it's pretty strong what happened. It's just that the salaciousness and the like sort of aggressive celebrity-ness of this case has made it something more. So I can't necessarily, pinpoint a specific case because these are anonymous cases. I mean, some of my cases did go to trial and were high profile, but high profile if you're into that kind of thing, right? I mean, the Times would, cover it, or the Daily News or the Post or whatever. But, if you're not a crime person, you're not going to necessarily see those cases. But they happen very, very sort of regularly. So I can't necessarily point you to a case, but I can say that the type of case, falsifying business records, is not an unusual one.
Interesting. So regardless of how the verdicts land, like would there be any precedent set either way? Either for paying off porn stars or whatnot. Like, because I am kind of legitimately curious about, like whenever Supreme Court has like a ruling or decision opinion, it's very precedent setting. So like, is there anything in this case that you feel could be precedent setting?
I mean, the only thing that's unusual here is referring to a federal election crime as the underlying crime for the falsifying business records. I think we talked about this before. State prosecutors don't really tread into the federal world. I was cross-designated as a federal prosecutor in one of my cases, but that was my only time. I never looked at federal laws when I was doing false filings or other things like that, because first of all, I didn't know it. I knew New York penal law. I knew and the various other tax crimes and things like that. I was usually able to find them. And as we talked about, I do think that those exist here too. So that's the only thing that I think there will be an appeal on that, and saying that was improper. And if the courts, the appellate courts, sustain that, that will certainly be new precedent. Other than that, though, I mean, as we've talked about, it's not illegal to pay hush money. You can pay hush money to anyone you want. What's illegal is misstating what it is. If it said hush money in the Trump registers, right? If they're their business records, we wouldn't be here. There'd be no crime.
That's funny. It's like hush money, 130,000 to porn star.
Yeah, there'll be no crime.
Wow. I mean, I think Trump might have some legal issues in his marriage, possibly. But
Sure.
So all right. So here's the $100,000 question, or here's the $130,000 question. Based on what you've seen so far, like how do you think this whole thing is going to conclude? Verdicts. How many of the 34 counts? And I won't hold you to the answer that you provide. So this is just.
Look, if I'm just another member of the public speculating. So all I can do is speculate. I don't have any special inside information on this particular trial. My feeling is they will either convict or there will be a hung jury. I would be very surprised if they acquitted outright. Um, and there could be a repugnant verdict where they convict on some and and acquit on others. That could happen because again, jurors are not lawyers, and sometimes they don't quite follow what the judge says, and sometimes the judge can fix that, and sometimes he doesn't. It really depends on the judge, but so I think that he'll either be convicted or there will be a hung jury. That's what I think.
So when you say hung jury, like that's different than the repugnant type of.
Yes, a hung jury. Sorry, a hung jury is when there is not a unanimous verdict. So in other words, 11 to 1, 6 to 6, 10 to 2. If you don't have enough people, if not everybody agrees one way or the other, either guilty or not guilty, that's called a hung jury, and that's a mistrial. And then there's a opportunity for the prosecutor to retry the case.
Oh,
So
interesting.
all over.
Do they so do they have to um, like a hung jury would be out of the 34 counts, they can't agree on the same sort of outcome for all 34? Is that basically what you're saying?
Well, theoretically, you could have a hung jury. So you could have convictions on some,
Hmm.
and you could have a hung jury on others. That would be, and that's not a repugnant verdict. That could happen. It's a little weird because it's again, it's the same. It's the same conduct. If you either, I feel like you either believe it or you don't. But theoretically, they could do that. That would be an appeals issue. Like, hey, well, that doesn't they didn't understand. They didn't understand the evidence. That's why they did that kind of thing. Um, so yeah, but the point is, if they cannot reach a verdict, that's a hung jury, and the prosecution has an opportunity to try it again. And I'd say, I was actually just asked this question by another reporter. I think in 25 years I had 4 hung juries, and 2 of them we retried and they were convicted. And in those cases, I do talk to the jurors because I want to know why they hang. And in those cases, it was either 11 to 1 or 10 to 2. It was just some kind of people that were, they dug in and they weren't going to deliberate. And it's America, you can do that. And then we retried them, and they were convicted. And the other 2, one of which it was actually a horrible case involving a push-in robbery by a neighbor, and the victim was like he was deaf and only and he had some developmental issues, and he was petrified. So the jury, honestly, they should have acquitted, but this is just interesting because the jury said there was one man who said, I could see this guy was petrified, and he's like, I knew that this guy did it. It's totally improper, but ultimately it was a good thing because ultimately we were able to work out a plea bargain. So in my other 2, there were plea bargains, so that when they didn't convict, they pleaded guilty. They didn't want to go through another trial. So Trump is another animal. Who knows what will happen?
Yeah. So last question, and it's sort of tongue in cheek, but like, yeah, have you been in that courtroom that they were talking about? Because a lot of the reports I'm reading, they say it's like really cold in there. Like the first.
I haven't been in the courtroom during the Trump trial, but I've definitely been in that courtroom. There's a lot of this is a building from, I believe, 1930. So it is not the systems are not great. It is either sweltering or freezing. I used to bring bring a blanket if I could. If I did things but I mean, it was literally, I would have to be discreet because I didn't want to look weird. But I remember under the table, I'd be like, this would be so cold. Or I'd wear like I would be more bundled up than you would imagine, like turtlenecks under suits, things like that. So yeah.
That's so funny. Well, thanks again, Diana, for your wonderful insight. I always enjoy talking to you, and you're just so smart, and I love that.
Thank you.
And
well, I love you ask great questions, and I think we have a lot of fun. Hopefully, it's helpful to your listeners, and always happy to answer questions. Thank you so much.
Awesome. Thank you. And to our listeners and viewers, thanks again for stopping by. And remember, keep your conversations not right or left, but up. We'll talk to you later. Bye.
Thank you.